Relevance of insurance provision to cargo interest liability to contribute in general average. Herculito Maritime Limited versus Gunfor International BV. On Friday, 4 December 2020, Sir Nigel Tier handed down judgment in Herculito Maritime Limited versus Gunfor International BV as a 69 appeal from an arbitration award of Timothy Young QZ, Dominic Kendrick QZ, and Simon Gold. Guy Blackwood QZ of Quadrant Chambers appeared on behalf of Herculito, the successful appellant, instructed by Richard Neyland and Jenny Selman at HFW. The case concerned two novel points of law: whether a war risk clause or equivalent in a charter party was incorporated into a bill of lading by general word of incorporation, whether provision concerning responsibility for the payment of insurance premium in a charter party could effect the obligation of a bill of lading holder to contribute to general average. The dispute arose out of the hijacking of the MV Polar, the vessel in the Gulf of Aden by Somali pirates in October 2010 whilst it was performing a voyage from Petersburg to Singapore pursuant to a voyage charter between Herculito and Clear Lake Shipping Ltd. Gunfor was the lawful holder of 6 bills of lading issued in respect of the cargo carried on board. The bills provided that freight was payable as per the charter party. The bills also contained general word of incorporation, which purported to incorporate term and condition, liberties and exemption of the charter party. The charter party had the following relevant clauses: a clause which permitted Herculito not to continue the voyage or to deviate, a clause which obliged Clear Lake to bear the expenses caused by the exercise of the liberties in above by Herculito, clauses which required Clear Lake to pay for additional war risk and kidnap and ransom K&R insurance to transit the Gulf of Aden. The vessel was released in August 2011 following the payment of a ransom of $7 million by Herculito. General average was declared, and in the usual way, cargo underwriters provide a general average guarantee and Gunfor a general average bond. An adjustment was issued pursuant to which $4 million was held to be the amount of Gunfor's contribution to general average. Under the term of the charter party referred to above, Herculito had procured war risk and K&R cover, which indemnified them for the entirety of the ransom paid. That claim was met with the defense that the charter party provision, which required Clear Lake to pay the insurance premium for the war risk and K&R cover, disentitled Herculito from claiming a contribution to general average from cargo interest under the charter party because the insurance provision were in effect a complete code, an agreement that Herculito would only look to the underwriters and not Clear Lake for any losses falling within the scope of the cover which had been paid for by Clear Lake. It was further argued that those provisions were incorporated into the bills of lading such that a claim could not be brought against Gunfor under the bills either. The award. The tribunal held that Gunfor's defense succeeded. It held that the charter party did set out a code for the losses resulting from the operation of on-voyage piracy risk in the Gulf of Aden area, namely, the Clear Lake agreed to pay the premium for the relevant insurance policies, and Herculito agreed not to advance claim against Clear Lake in respect of losses which fell within those insurance policies. The tribunal further held that the obligation to pay extra insurance premium was incorporated into the bill of lading contract and, therefore, the same code applied as between Herculito and Gunford. However, the tribunal also held that even if the obligation to pay the extra insurance premium wasn't incorporated into the bill of lading contract, that didn't matter, since within all the matters is that the charter code involved an agreement by the owners not to seek contribution for piracy losses. It is not a case of incorporating a positive obligation on cargo, but of an agreement by the owners excusing cargo from liability. The judgment of the Commercial Court. Sir Nigel Tier identified three principal issues which failed to be determined. Whether charter party provision concerning the payment of insurance premium incorporated into the bills of lading was the effect of the insurance provision in the charter party, such as to prevent a claim being made by Herculito against Clear Lake under the charter party? Was the effect of the insurance provision in the charter party, such as to prevent a claim being made by Herculito against Gunford under the bills of lading? Issue 1. Incorporation. Sir Nigel Tier set out at paragraph 34 the well-established principle of incorporation of charter term into a bill of lading contract, supplemented at paragraph 35 with some additional observation found in the authorities. In applying those principles, he held the word of incorporation in the bills of lading were wide enough to incorporate the relevant clauses from the charter party. The obligation to pay for additional war risk and K&R cover to transit the Gulf of Aden was directly germane to the carriage and delivery of the cargo under the bills of lading, in that the bill of lading holders would expect the vessel to proceed on its voyage via the Gulf of Aden and would have understood that Herculito might have to take out such insurance. That the key question on incorporation was whether it was appropriate to substitute the word holder of the bill of lading for charterers so as to make the bill of lading holders liable under the bill of lading contract to pay the insurance premium. He held that it was not appropriate to do so for two reasons. Firstly, the price to be paid by the bill of lading holder for the carriage of his cargo to Singapore was freight as per the charter party. As such, the judge held that clear word would be required to impose a liability not only to pay freight but also to pay the additional insurance premium as the price for the carriage of his cargo, and there were no such clear word. Secondly, the bills of lading gave no indication as to what each bill of lading holder was to pay, given that the additional premium was for the entire voyage and not on a per bill of lading basis. Given the lack of any wording in the bills addressing the purchase liability of each of the holders or how the premium were to be apportioned, that was a further indication that the parties didn't intend the charterer should be substituted by bill of lading holder.